time is now 12:36 p.m. The House Committee on Criminal Jurisprudence will come to order. The clerk will call the roll.
Chair Moody,
Present.
Vice Chair Cook,
Here.
Representative Bajani,
Here.
Representative Bowers, Representative Darby, Representative Harrison,
Here.
Representative Leach,
Here.
Representative Christina Morales, Representative Schatzline.
Here. A quorum is present. Some housekeeping matters first. I apologize for those of you who've been waiting. The Committee on House Administration has approved a process for the electronic submission and posting of public comments for each item on today's agenda. The public comments submitted through the portal will be posted on the Electronic Legislative Information Systems, TLIS and TLO, as well as on the House website. At the conclusion of today's hearing, directions of how to submit public comments on the portal can be found on the meeting notice for this hearing. Today, the committee will hear from invited witnesses only. If you have not filled out a witness affirmation form already, please notify the clerk and we will remedy that problem. Due to capacity constraints in this hearing room, we have 2 overflow rooms set up for anyone present and wanting to watch the live stream of today's proceedings. Those rooms are E1014 and E1026. First and foremost, I want to thank everybody for being here. I apologize for the delay. As anyone who has been following this matter, there is an enormous amount of litigation around this topic. There's an enormous amount of conversation around this topic. And so many of us have been working through that. Did not mean to keep you waiting, and so please accept my apology for that. Today we have an impressive slate of witnesses who I think will surprise everyone and add important dimension to these issues. The most important witness, of course, is Robert Roberson. I'm very disappointed to say I don't believe that will happen today, and I'd like to go over why that is. As many are well aware, there's been a flurry of litigation in the Texas Supreme Court over the weekend. The upshot of that is that a valid legal subpoena for Robert remains in effect. If this committee wanted to take a heavy-handed approach, there are dramatic ways that we could enforce that subpoena. But we didn't issue the subpoena to create a constitutional crisis, and we aren't interested in escalating a division between branches of government. In fact, we have the greatest respect for every other facet of our government, and we want all of them to come together in our purpose here, which is making sure that Robert is heard. There's been a lot of discussion about video conferencing Robert in today. I believe that that'd be perfectly reasonable for most inmate witnesses. But Robert is a person with autism who has significant communication challenges, which was a core issue that impacted him at every stage of our justice system. He's also spent most of the last 2 decades alone, locked away from the modern technology we now take for granted. Video conference is poorly suited for Robert specifically to provide his testimony and would only further the harm he's already suffered. When I thought about the accommodations to be made, I considered his needs as a person with a disability above all other things. I also weighed the fact-finding needs of this committee, the entire purpose of the subpoena. Weighing those with the concerns that were outlined by the Attorney General, our committee simply cannot agree to video conference. That doesn't mean Robert won't testify at all. In the spirit of cooperation, we are in talks with the Attorney General's office right now about ways their position can be addressed while allowing our committee to hear Robert in person. I expect a quick resolution to these discussions, which are ongoing even at this moment, and I will update everyone as soon as those plans are finalized. At this time, I'd like to invite any member of the committee to make any opening remarks. Mr. Vice Chair? Chairman Leach.
Thank you, Chairman Moody, and thanks to those of you who are joining us here at the Capitol today, and to my fellow committee members, fellow legislators here in the room, to Texans who are watching on television, and welcome to all of the non-Texans who are tuned in across this country and really all over the world. We are honored to sit in front of you today and, unlike Washington, to show you that government can work and that Republicans and Democrats can work together, that death penalty supporters and death penalty opponents can work together, that the branches of government, the legislative, the executive, and the judicial branches can work together. When it comes to our fundamental duties as legislators, it's very simple: to protect at all costs the fundamental rights and liberties of the people, most importantly of which is the right to life. And when it comes to the life of a potentially innocent Texan, someone who I have, over the past several weeks, grown from having questions and concerns about to believing he is fully innocent, and was within 20 minutes and 20 steps of being executed by the state of Texas just days ago. If we can't speak up and step up and work together to fix a system that is not broken in and of itself, but that needs fix, that has failed Robert and failed Nikki, then what are we even doing? Today, this hearing, the purpose of this hearing, our purpose for coming together and issuing a subpoena to Mr. Roberson and to convening last week and today and in what is likely a subsequent hearing is to ask questions and to find the truth, to figure out where the system went wrong, where it failed Nikki, where it failed Mr. Roberson, and to try to fix it, not only in his case, but to make sure that it never happens again. In closing, I'd like to make very clear, members and Mr. Chairman, remind ourselves that when we take our oath of office, we solemnly swear that we will faithfully execute the duties of our office of state representative of our state, the state of Texas, and will, to the best of our ability, preserve, protect, and defend the Constitution and laws of the United States and of the state of Texas. That oath of office I take seriously. I know each of you take seriously. And importantly, that oath of office is the same oath that judicial officers and executive officers take. And the legislative branch today is taking our oath seriously. And I'm honored to be here with our fellow members, and I welcome all the people tuned in to the Texas House of Representatives. Thanks for joining us today.
Chairman Darby.
Thank you, Mr. Chairman. First of all, thanks to the members of the committee for being here today, and thanks to the members of the public and other fellow members of the legislature that are sitting in the third row. I want to build on Vice Chair Leach's comments about our role here today. I'm probably the senior member on the dais this morning. I've been here for a few sessions, and I want to focus the committee and the Texas House on our role and responsibility under our Constitution. Our job is to pass laws, and we do so because we listen to the folks who elected us to come down here and make those decisions, to do the hard work, to focus on an issue, come up with the right policy, and then hopefully we'll pass that policy and it'll make a difference in people's lives. Over the years, certainly during my time here in the legislature, there was a flaw in the system. There was a flaw in the habeas corpus process. There was not a mechanism by which people could appeal to the court to grant relief in a situation where science has changed. Now, they refer to it as junk science, but I would say it's just science has changed. The knowledge has changed. And so we saw problems. So in 2013, and I think Chair Moody and Chair Leach were members of this committee at the time under Senate Bill 344, this legislature took up this issue. We said, let's create some basis of understanding that would allow relief for people who've been charged and are serving time to address the concern about changing knowledge of science. We did that. We set up steps that the Court of Criminal Appeals could look at. Well, we didn't go far enough. And 2 years later, in 2015, we revisited the issue and we changed it again. We changed the steps. And so what I would like this committee to focus in on, what I'm not here to determine guilt or innocence. That's not my job. What I am here to do is, has the legislature failed in properly addressing the tenets by which the Court of Appeals can review these cases. And since the implementation of this law in 2013, there have been 74 applications for writ of habeas corpus based upon junk science. Roughly 25 of those cases were people on death row. None of those cases have been affirmatively reviewed and remanded. None of them. The other approximately 50, 2/3 of those, well, about half of those have been sustained. That science has indeed changed, and so we're going to we'll allow new evidence to support a rehearing or a retrial on that case. All of those cases pertain primarily to DNA analysis. We all have gotten caught up with DNA, and we understand that science, and so we recognize that has the ability to determine that the accused didn't do it, but somebody else did. But there's no cases that have been successfully appealed that take a look at the tenets for the shaken baby syndrome that we're dealing with today. Clearly, that body of evidence has changed. And so it's up to this legislative committee to look at the tenets of what's going on here. Has the Court of Appeals taken a position that is inconsistent with the statutory language that we have set out for them to follow? Are they ignoring that and saying, well, yes, it's changed, but it does not determine who the guilt or innocence? That's a level beyond which I originally envisioned in 2013 and 2015. That's a higher level. Is that a level this committee and the legislature wants the Court of Appeals to review these cases? That you actually have to have the scientific facts determine the innocence of the accused? I think not. And in this case, I think so we need to be looking, what I'm looking for with the witnesses is how are we as policymakers to look at the statute that says this is the criteria by which and the lens by which we will review the facts of this case and determine whether or not a new trial should be justified. That's what our business is. That's what our business is, not to determine guilt or innocence. It's not to argue about the death penalty. It's to determine that we as legislators have created hurdles in statute. And is the Court of Appeals following those hurdles in the spirit by which we were intending them to follow? That's what this committee is about. It's not about guilt or innocence. Guilt or innocence will be a byproduct of our hard work. Thank you, Mr. Chairman.
Chairman Darby, thank you very much. Representative Harrison.
Thank you, Chair. I want to start off by thanking everybody who's taken the time to tune in or come to this incredibly important hearing today. And I also want to start off by thanking every member of the Criminal Jurisprudence Committee for voting on a bipartisan unanimous basis for the issuance of what was admittedly a historic and wholly unprecedented subpoena. I'm grateful for each one of you for taking such a bold action that even though it was historic and without precedent, I firmly believe it was absolutely necessary given the extenuating circumstances in this case. And without wanting to get too philosophical, I do want to remind everybody that in our country and in our state, in the great state of Texas, it is the people who write the laws that govern them. And they do that via their elected representatives in the legislature. So it is incumbent upon us to make sure that the laws that are duly enacted by the legislature are being faithfully adhered to by those who are subject to them. And so for people out there who have concerns, who have raised questions about separation of powers, I want to be unequivocally clear. If you care about the maintenance of the proper functioning of our constitutional system of separation of powers, you should be the loudest supporters and the biggest proponents of what this committee is doing here today. If the House of Representatives cannot exercise legislative oversight to make sure that our laws are not just being faithfully adhered to, but that they are not potentially being so egregiously violated that it may result in the life of a potentially innocent person being taken by the government, then I would posit there may be no matter that could be subject to legitimate legislative oversight. The role of government, ladies and gentlemen, is the protection of life and the protection of our liberties and our freedoms, which do not come from the government, but that are endowed, as our founders knew and codified in our founding documents, in an inalienable fashion, endowed to us by our Creator. And it's the central role of government to protect them. So especially when we are weighing something before us as constitutional officers of the state of Texas, where a man's life literally hangs in the balance, and we are contemplating the government exercising the ultimate and most awesome power that we give a government, and that is to take a life, we cannot get this wrong. And I say that as somebody, ladies and gentlemen, I want the state of Texas to lead the nation in just about everything. But executing potentially innocent people is not one of them. I do not want my children, and I think I can confidently say this for my colleagues on the dais here, I do not want my children to inherit a state where potentially innocent people may have their lives deprived from them by the government. So in closing, I want to just thank not just my colleagues on this committee, but every single member of the Texas House of Representatives who has spoken up and has unified and is making the conscious decision to put aside partisanship and put aside the issues that usually divide us so that we can come together in the pursuit of justice. Thank you, Chair.
Thank you, Representative. Any other members have opening remarks? Yes, Representative Bowers.
Thank you, Mr. Chairman. And I don't have much to say, but I just would like to say thank you to all the members of this committee for every bold and courageous move that was made by those here on the dais as well as those that are out in the audience. There's a higher being that knew that each of us in this room would be here today at this moment and for this time. And so I just want to say thank you all for being here. And it is historic that we are all sitting here and we are going to make some decisions that hopefully will bring positive change to this state. Thank you.
Thank you. Any other members with opening comments? Nope. Okay. Before I begin, I'm going to just let you know who the witnesses are that we'll be hearing from today. I'm going to list them in an order that I intend to call them. I want to be very clear that those things can change with schedules and logistics, but I'll go through that list now. Dr. Philip McGraw, John Grisham, the Honorable Elsa Alcala, Terry Compton, Kate Judson, Don Salzman, Dr. Natalie Montfort, and Gretchen Swine. At this time, the chair calls Dr. Philip McGraw.
Matter which one?
Choice is yours.
Right.
Now, Doctor, we don't probably have the same audio capabilities that you're accustomed to. No disrespect to the House administration, But these microphones are directional, and so want to make sure that we're able to hear you. Before I
Okay.
do turn it over to you for your testimony, I do have to do a little bit of housekeeping. I have you registered as a witness as Philip McGraw, PhD. You are here testifying on behalf of yourself, and you're testifying neutrally on the topic being considered today. Is that correct?
That is correct.
All right. Sir, I appreciate you taking the time to be here, and I don't want to belabor the point, so we'll go ahead and turn it over to you to offer your testimony. The members up here may have some questions following up after your testimony, but we look forward to hearing from you. Thank you, sir.
Well, thank you, and let me tell you, it's an honor, a privilege, and a responsibility to be here and address this committee and this important topic. And I'm here today to speak about my experience with Robert Roberson and learning about his case. And I want to talk about what I've done to be able to speak about this. I've reviewed the transcripts and supporting documents from his trial. I've done an intensive forensic interview with him, and I think I am in a position to do that because a lot of my career, decades, have been spent in the legal arena, both civil and criminal. And in terms of my training, so people know, I do have extensive training in clinical psychology and behavioral medicine or medical psychology from the great University of North Texas in their PhD program. And then I completed a postdoctoral fellowship in forensic psychology. And spent a lot of time working in the litigation arena for a big part of my professional career. And not to bury the lead, I am 100% convinced that we're facing a miscarriage of justice here. I say that because I do not believe that Mr. Roberson has had due process in this case. I do not believe he has yet enjoyed a fair trial in this matter. And I'll talk about that in detail. I believe that in the United States of America, if we are going to deprive someone of their liberty, that comes at a very high standard. If we are going to deprive someone of their life, that comes at a very high standard. A very high standard of proof, a very high standard of evidence, and when you say beyond a reasonable doubt, that's said so much that I think sometimes it can lose its meaning, and we have to really stop and think what that means. That means that if you have 12 people on a jury, that means that there should be nothing that 12 people can go in a room and reasonably disagree about. And that is a high standard, that there should not be anything that they would go in there and say, well, there's nothing here that we can reasonably disagree about. And I think that when we talk about due process and fair trial, that means that all the evidence, everything that is relevant and pertinent to that trial gets before the trier of fact, whether it be a judge or a jury, and that there's fair representation. And I certainly don't think that standard has been met here, that high standard by which we would deprive someone of their life has been met. And I think that the death penalty actually hangs in the balance here, because if we get this wrong in a case like this, I think that the death penalty
could come under real attack. And there are circumstances where I personally believe that it is appropriate. I think back to James Byrd Jr. on 6/7/98 when he was dragged by King and Brewer in Jasper, Texas. And subsequently, Brewer was executed in 2011 and King was executed in 2019. A third man got life in prison. I look at cases like that and think, you know, there are times where the death penalty just seems appropriate. And it would be I think it would be unfortunate if that was taken off the table. I'm also aware in circumstantial cases how powerful it is for an expert, a physician, for example, to come before a jury and render an opinion. And I've spent so much time in cases and debriefing jurors after a case and know how heavily that weighs on those jurors. And I believe in this case that there was what I would refer to as triad tunnel vision, because there was a shaken baby syndrome that was defined by a triad of symptoms. And those symptoms were subdural hematoma, brain swelling, and retinal hemorrhaging. And that was believed to define the syndrome of shaken baby. And we now know from an evolution of science that that's just simply not the case, that there are a number of other explanations for those syndromes, and that causation has actually been debunked. And as a result, the Daubert test, junk science, it's just been debunked as it's no longer a standard that you can look to in defining that. And I think that once that was looked at as the order of the day, everybody got tunnel vision. And, you know, there's something in psychology known as confirmation bias. And it's been around for a long time. Bacon first talked about it in 1889. And confirmation bias is the tendency for people to make up their mind to something, and they close off openness to alternative explanations. They seek and find and hear and process only data that supports their initial belief. And they turn a deaf ear, a deaf ear and a blind eye to anything other than what they passionately believe to be the case. And I think we have clear evidence that that's what happened in this case. The decision was this triad of symptoms were written down, and it started with the doctors that were looking at this first, and then it trickled down to investigators and police and went right through the trial process, including Mr. Roberson's defense counsel, including his own counsel. And I've heard and read those that are opposing these efforts say that, well, this really wasn't the crux of this case. It wasn't really what was going on here. And I'm sorry, but I've studied this trial transcript, and it was the crux of this case. It was the center of this case. In one summary that I've looked at, as well, I've read a summary and I've read the actual transcript. I stopped counting at 47 times it was mentioned in the trial transcript. Shaken baby syndrome, shaken baby case, shaken baby syndrome, shaken baby case, triad of symptoms. And let me tell you something that will seem incredibly obvious, but it is not. Juries decide these things on what they see and hear, not on what they don't see and hear. And you would think, well, yeah, but my point is, I've often seen lawyers try to get something into the record and it's kept out, and heard them say, well, we didn't get that in, but the jury knows we had something really powerful, and that's going to stick with them. No, it's not. They decide on what they see and hear, not what they don't see and hear. And there was a massive amount of outcome determinative, exculpatory evidence that was never reviewed. It was never put in front of the jury. It was never heard. And you always hear, and the law is clear, that the burden of proof is on the prosecution. That Mr. Roberson does not have to prove that he didn't do this. The prosecution has to prove that he did. And that's great in theory. But having spent decades in the litigation arena, I can tell you, debriefing juror after juror after juror after juror across decades, they have taught me that they sit back and say, if we're not down here for the reason that the prosecution says we are, somebody needs to explain to me an alternative explanation. Because we know these cases get resolved 100 different ways before we ever get to this point. So if we're not down here for the reasons that they say we are, somebody needs to explain why. They're looking for an alternative explanation. And in this case, oh my gosh, was there an alternative explanation? This child was an ill baby. From 8 days old, the medical record shows this child was not well. The record shows that this baby had 46 doctor or hospital visits in her 23 months and few weeks of life. In the days leading up to her death, the record shows she had 104.5 temperature. The record shows that Robert took her to the doctor twice in the week leading up to her collapse. The record shows that she was prescribed Phenergan on 2 separate days leading up to her death. A black box warning says you do not prescribe this medication to someone under 2 years of age. On the second administration, it was Phenergan with codeine, a double impact that suppresses the respiratory system. We did not hear that this child had severe pneumonia. We did not hear that. And there were scans available to be looked at, and the medical examiner admitted that they were not looked at. And I will provide to the committee, this is a calendar of the 2 years of this child's life, and every red notation is a doctor or hospital visit during her young life. This was a child that was acutely and chronically ill. And when I say that this child had been diagnosed with interstitial pneumonia, on the left is a scan of her lungs, and the pinkish red is non-functional lung tissue, according to the doctors, and I'm telling you just what the report says. I'm not playing physician here. And on the right is a normal lung. This never got in front of a jury. Why? Because it was never looked at. It was never looked at. The medical examiner medical examiner did not review this and said so. This child had collapsed several times when Robert Roberson was not in this child's life. This wasn't the first time this child collapsed and turned blue and had respiratory shutdown. It had happened a number of times when he wasn't around. On this occasion, he was around and took the child to the hospital. So how was this case tried without all of this stuff being put into the record? It's astounding. It's astounding. Even the defense counsel, who did nothing to challenge the evidence, stipulated that this was a shaken baby case. During voir dire, I'm quoting defense counsel, "Every one of you related to that you had heard the term shaken baby, that it was an act of basically a lack of control of emotion. It's a bad thing, but it's not something that rises to the level of capital murder." His own counsel says this was a shaken baby case. In opening statement, his defense counsel says, "This is, however, a shaken baby case. The evidence will show that Nikki did suffer injuries that are totally consistent with those applied by rotational forces, more commonly known as shaken baby syndrome." Now, Robert Roberson was offered plea deal after plea deal after plea deal and never took a plea deal because he said, "I never did anything to this child. I never put my hands on this child in anger. I didn't hurt this child. I didn't do anything to this child. I'm not going to take a plea deal for something I didn't do." But yet his counsel stands up and says, more commonly known as shaken baby syndrome. On page 35 of the closing argument, defense counsel says, "Yes, I came here in opening and presented to you that there is responsibility in this case. Yes, this is a shaken baby case, but no, this is not a murder case." His counsel is stipulating this is shaken baby, and the science has marched on and now rebutted that shaken baby syndrome is a valid medical syndrome. Has said you cannot rely on that. That is junk science. We've now evolved to a level that says we know that shaken baby, as defined then, does not create that triad of symptoms, and that triad of symptoms can be created by a number of other things, such as over-medication, pneumonia. You could just go down the checklist here of what happened in this case. It has been reported that there was an expert psychologist that supposedly recommended to Robert, just take a plea deal, go to prison, and you can kill yourself once you're there. Now, I can't verify that. I can just tell you it's in the record and has been reported. But yet he refused those plea deals and went to trial, where the jury was wrongly told that abuse could explain, that only abuse could explain the death, and they heard nothing about this child's acute or chronic illness. Now, there's another factor that comes into play here. The jury was told that Mr. Roberson was guilty because he didn't respond in an expected way at the hospital when he brought the child in. flat affect. They were not informed that he was autistic. And that did not come to light until 2018, many years later, when he had an active counsel that actually got him examined and formally diagnosed. We see all through this man's life, which was not a spotless life, let me tell you. He got involved with drugs at one point. He burgled a house at one point, violated his probation, but never is there any evidence of him being violent with other people, assaulting other people, having impulse control disorder, rage, anything of that nature. There is testimony that he was bullied because he was different and lacked social skills that are typically associated with autism or frequently associated with autism, but he never retaliated. I sat across from Mr. Roberson at the Polunsky unit, and I've spent a lot of my professional career studying and practicing deception detection and interrogation. I've worked with law enforcement locally, federally, in developing these skills and techniques. So I didn't just go have a therapy session with him. I didn't just go talk to him. I was very mindful of deceptive behaviors, and I'm the first to say there are no lie behaviors. People talk about that like there are lie behaviors. There are not. But there are behaviors that correlate with lying. There are behaviors that show up when someone is goes into a stress mode that is associated with not telling the truth and creating something that is misdirection, trying to take you away from something they don't want you to know about them. I ask him hard questions. I ask him point blank, straight up, looking him square in the eye, did you harm this child? Did you shake this baby? Did you put your hands on this child in anger? Did you neglect this child? Did you fail to get this child to a hospital in a timely fashion? He said he had been criticized for putting the child in the car and racing to the hospital instead of calling 911 and waiting for the ambulance. He said he made the judgment call. He could get her there faster. But he was forthcoming and straightforward. It took years for specialists to put the pieces together, the pieces that the medical examiner never did. And I think sometimes, with my years in the litigation arena, that sometimes we forget that the goal of prosecution is to seek justice, not conviction. I think sometimes in the heat of battle and with so much time invested in cases, that it's easy to forget that the goal is to seek justice. And if you get in the middle of a case and you determine, wait a minute, I've got the wrong person here, or I can now see that no crime was committed, that this was a case explained by medicine. This was a case explained by disease. I need to walk away from this one. And when you have a medical examiner that has admitted they never looked at the child's medical records, including the final week where there were multiple doctor visits, And even the child's last 2 days, when extraordinary efforts were made to save the child's life, which meant there were efforts made to stop the swelling and relieve the pressure in the brain, yes, there were things done to the child's head. But if you look at the pathology reports, they contradict what was concluded at the time, that there were multiple blunt force trauma to the baby's head. You look at the pathology reports, they say that's not true. There was one minor trauma to the head that would come if the baby fell out of bed. All of those things were available. And these things not being considered, that's on the state that's seeking to execute this man. And that's why I say there was not due process in this case. There were people that, in my opinion, did not do their job. No one, including me, can say with 100% certainty what happened in that house that morning. My professional opinion is that this is not a man with malice. This is not someone that hurt this child. What I can tell you that goes beyond opinion, after examining the record in this case, the trial transcript in this case, the medical records in this case, this man has not had due process. This man has not had a fair trial. And if we start executing people in Texas absent due process, absent fair trial, we are going down a really dangerous road. That is not something that I can support. And I know that has not happened. As I say, it's a very high standard to take someone's life. We must have the courage to make choices that matter at times that count, and it is always the right time to do the right thing. I welcome this committee's questions.
Doctor, thank you very much, and I appreciate your testimony. I do have a couple of follow-up questions, and then if there are other members that have questions, I'll defer to them as well. I want to focus on Robert's autism. Can you help explain the disconnect that there is between interior life and external expression? How does that present itself with someone with autism, and how does that affect a person that's in the criminal justice system?
Well, how much time do we have? Autism is not a one-dimensional disorder, and that's why it's referred to as spectrum, because there is a broad range of how autism expresses itself, and it can change across time. What we do know is that there is a difference between internal experience and external expression and interaction. And you certainly see that with Robert. I think that Robert is very flat of affect. I think he is not cognitively agile in expressing himself, and he is emotionally not well developed in terms of expressing, showing emotions, or interacting with someone on an emotional plane the way you would experience 9 out of 10 people that might not be on the spectrum. So you're not going to get a typical response from him in a crisis situation or a normal situation. And having spent 21 years on death row, which is very confining and absent a lot of the stimulation that people normally get, that's going to worsen and deepen the situation in most cases. And as I say, every situation is different. I can speak to Robert's situation in that his world has constricted, as you would think, anyone that's confined in that kind of a space. But to his credit, he has distinguished himself. And he is one of very few that has elevated himself to have some freedom to move about the pod. He has a pretty much spotless record on death row, disciplinary-wise, problem-wise. And he, as someone that is very convicted in his faith and is a strong believer, and he does have people that come and see him and visit with him. In fact, the investigator that led the prosecution efforts at the time comes and sees him on a regular basis, and he's gotten comfortable with him. And that investigator has completely changed his position, believes he made a mistake in pursuing Robert at the time, has asked his forgiveness, which Robert has graciously extended to him. And the two of them have a pretty comfortable relationship where Robert can speak to him openly. And he was much more comfortable by the time I got through talking to him than he was at the beginning. But still, he had very pushed verbalizations. He had a difficult time with eye contact. He had a difficult time relating and responding in what I would call a predictable way that you would expect with someone that was functioning absent the autistic diagnosis.
How long did you sit with him on that occasion?
They give you exactly 60 minutes, and I made sure I got every second from start to finish on a stopwatch.
How far apart were you? What was the physical?
There's
setup?
glass between us. He's on the phone and I'm on the phone, but we're maybe 3 feet between us.
You've conducted interviews over video conference?
I have, and I've conducted a number of interviews on death row with the glass between myself and the interviewee many times before.
Is that something that would have been effective in your meeting with Robert, given his condition?
You know, it's kind of they bring him into a small room. It's probably 3 feet wide, maybe 5 feet deep, and he sits at a desk much like I'm sitting here. And the glass is kind of at the front edge of this table, and he kind of leans in on the phone. And it's kind of a comfort zone for him. I mean, he doesn't like a whole lot of stimulation, but you know, he leans in and participates. And I ask him a variety of questions about history and what he could remember and not remember. And you know, some things he didn't have clear memory of, and he owned that. I asked him questions to test his abstract thinking. He did not do well on those things. I challenged him when they said they wanted to go see his home where he found her and brought her in. And he said, "Sure, I'll take you right over there." I said, "Does it strike you odd?" And there's of course a video record of this, so you can see exactly how that exchange went. But I said, "Did you feel bad? Your daughter's fighting for her life there, and they say, I want you to get in the car and take me home. Did it occur to you that I don't want to leave? I want to stay here with my daughter?" And he was like, "Well, that's what they told me I needed to do, so I took them home. I mean, that's what they told me to do." He was very compliant at the time. I said, "Did you want to leave?" And he's, "Well, that's what they told me to do." That's what I mean. He's a very compliant individual, and he didn't have the ability to express the emotion, "I'm not going to leave my daughter." He just complied and did what he was told.
So and that's what I was trying to drive at. And you've mentioned that he had a comfort zone. So if someone like Robert's out of his comfort zone, he's got limited affect and emotional range, limited mental agility, like you said. All of those things I would think would be exacerbated if he's appearing on a screen and seeing others on a screen, as you and I learned how to do during the pandemic.
Well, yes, I think he needs every cue that he can have to grab onto and relate. You put him two-dimensional, and he doesn't, he needs cues. He needs physical feedback, and it makes it difficult if he can't have that. And his ability, we have to do everything we can to help him assist in his defense. And we can see from the trial record, 22 years ago, he didn't have a very good facility to assist in his defense at the time. If he had, even when he was there every day with his lawyer sitting next to him, if he had the ability to say, "Wait a minute, I've told you, I've turned down plea deals, I don't want to do this, why are you standing up saying this is shaken baby case?" If he had insisted that, look, this medical examiner's not talking about the evidence here. I mean, the cause of death was the child had a bacterial infection, was septicemic, and had a necrotizing infection that was eating lung tissue. If anybody here had been in that situation, we'd be saying, "Hey, we need to be talking about this. You don't need to be telling them something I've told you I didn't do. We need to be talking about an alternative explanation about why we're here." And he had a difficult time doing that when he was present at trial. If he had been on a screen, the ability to initiate contact when he's not in the room would be nil.
Okay. I have one more question for you, and then I want to pass it off to my colleagues that have questions. If someone was sitting in that other chair next to you and their testimony was to this committee that this was not a shaken baby case, how would you reply to that?
Say that again.
If someone was sitting there next to you and their testimony to us was this was not a shaken baby case, how would you respond to that?
Well, I agree. It was not a shaken baby case.
Sorry, I apologize. That it was a shaken baby case.
Yeah, I was trying to figure out where you're going with this.
I apologize. That if they,
Well, first thing I would say is there's no such thing as shaken baby syndrome. Now, listen, if I'm not asking people to believe that a full-grown adult cannot pick up a 20-pound child and do serious or fatal harm to that child. Of course they can. Of course they can. They can pick that child up and bash its head into a wall or throw it on the ground or whatever. but there are going to be very clear signs of that having happened that were not present in this case. What is known as shaken baby syndrome depends on this triad of symptoms: subdural hematoma and brain swelling and retinal hemorrhaging that you see in the eyes. That triad of symptoms has been debunked, that that's not what happens if a baby is shaken, and that there are a myriad of other causes, such as over-medication or absence of oxygen to the brain, or septicemia, other things that can cause those symptoms. If there are alternative explanations, then that's no longer a valid syndrome. And there have been a number of exonerations because of this. That was the science at the time. Science evolves, just like DNA technology evolved, and so there have been exonerations with DNA. The same thing here. There have been a number of shaken baby convictions that have been exonerated because they have come back with new science that says there's an alternative explanation for this. You can't convict someone on something that has now been debunked by the medical community. Even the individual who initially identified shaken baby syndrome said that was not the intent. I did not intend for that to be used as a prosecution for injury to a baby, and it has been debunked and disproven by the medical profession and is not used. So fortunately, science has progressed, medical science has progressed, and there's now new evidence available that should be used.
Well, I appreciate it. I do want to apologize for misspeaking. I was up at 3 a.m. to make a flight here today. So apologies for that.
I know
but-
you've been very busy.
But thank you I appreciate your testimony. I may have some questions following up a little bit later. But what I'm hearing from you very clearly is you've read the transcripts, you've reviewed the record, and there is not any way that someone could maintain that that the state came here and said that they didn't try a shaken baby case. That's what they told us last week. No, we didn't try a shaken baby case. Sounds like you've reviewed the record, and it sounds like your opinion is those facts speak loudly that is what they tried to do in that case.
Well, as I said, I stopped counting it 47 times in the record, and I read you quotes from the defense, certainly what the defense attorney tried. That was in voir dire, opening statement and closing argument, quotes from the defense attorney stipulating this was a shaken baby case, despite Robert's assertions that that was not the case, and he rejected plea offers and said, I'm not going to take a plea on something I didn't do. But yet then they got up and said, well, he did do it. His own lawyer said he did do it.
Thank you. Vice Chair Cook.
Thank you, Mr. Chairman. So, Dr. Phil, before you became Dr. Phil, can you tell us a little bit more about CSI? I think you've been a little modest so far when you said you've been involved in litigation. I want you to be a little more specific about your background.
As I say, I had kind of three areas of focus: clinical, the medical psychology, and my focus in medical psychology was brain and central nervous system. And then I did a year's postdoctoral fellowship in forensic psychology, or psychology in the law. And I was a founder of a company called Courtroom Sciences, Inc. It was the original CSI. Probably should have enforced that.
I think so.
But we had a full-service trial science firm, and we were retained by clients to evaluate cases and We did strategy for cases. We assisted in jury selection, witness preparation. We often had mirror juries, shadow juries in the courtroom that matched the jury that was in the jury box, and we were able to debrief our jury. So what I'm saying is, if we had 12 jurors in the box and there's 7 women and 5 men, then we had 7 women and 5 men in the gallery that matched them. So if we had a 42-year-old woman with 2 children, a barking dog that was a Baptist with a year of college, then we had a woman out here that was 42 years old with 2 children, barking dog, a year of college that was a Baptist. Because you can't talk to the jury every night, but you can talk to your shadow jury every night, and it gives you insight to that. We mock tried cases many times before they went to actual trial to find out, how a jury in a particular venue was likely to view a case, and what was important to them and what was not important to them. The difference was at mock trial, instead of having one jury, we seated 4 or 5 or 6, and they went to independent deliberation rooms, deliberated over the actual jury charge as best we could predict what it was going to be, and all of that was videotaped and then analyzed very carefully to see what their problem-solving strategy was going to be, what was important, what was not important, so we knew what to emphasize and not emphasize. Whether this particular expert was effective or the other expert was more effective, what they wanted to hear and not wanted to hear. And we focused on telling the truth effectively and getting the best result we could. And sometimes the answer was, you need to settle.
Sure.
Thank you. And we did criminal cases and civil cases, both.
Well,
Defense and plaintiff.
as a former client from a couple of decades ago, I've seen you in action, and I can attest to your skill set. And just want to say thank you for being involved in this case. Thank you for being willing to be here today and take time out of your busy day now that you're Dr. Phil in a different role than what I knew you as a couple of decades ago. But I think I just wanted everyone to know that background. It's not like it's not the typical person talking to a few jurors. You've done this for decades, correct?
I have.
And you said you read the record. Did you see discussions about a sexual assault of a child involved in the record?
I saw discussions of the sexual assault early on. It was brought up concerning 3 anal tears in a child, I believe it was. This was early on, and it seemed to me that it was brought up to prejudice the jury, frankly. But then it was dropped out later and was not part of the jury charge. It was not something they were asked to render a finding on. And it was not something that they prosecuted on at all. I felt like it was there because it's, if you want to inflame a jury panel, then you can put that into the mix. But then it was completely dropped out. It was not paid off. There was no evidence offered about it. No testimony was given about it. There was nothing in the medicals that were offered about it. It was just put in early, but then it was never paid off later.
Fair to say, if we were to grab 100 people off the street, that probably all 100 of those people would agree that that would prejudice the jury, that they heard that type of testimony prior to going to deliberation.
Well, it certainly would, and but as I say, in opening statement, you're not allowed to argue. You're just you're just going to say, we believe the evidence will show, and then the jury is expected to see, well, they made that promise. Let's see whether they bring it or they don't. And then in closing argument, the opposing attorney would be expected to say, they stood up and brought this up. Did they ever show you anything to do that? And with something that inflammatory, there's a real question about whether you even want to bring up that they didn't pay it off, because you're reminding them, and it puts it back into the juror's mind. So do you bring it up again, or do you just leave it there? It's a difficult call. But if you examine the record, you will see that there was never one word of testimony from an expert or otherwise to show that there was any even insinuation. And Dr. Francis Green filled out an affidavit on July 9th of this year, and she basically said in her affidavit that if she was going to render an opinion on what the cause of death was and what she saw, there was certainly no mention of that. She disagreed with the cause of death, and she had a firm opinion that the death was caused by severe undiagnosed viral pneumonia, onset of which occurred at least a week to several weeks before her collapse, that there was a viral interstitial pneumonia complicated by secondary necrotizing bacterial bronchopneumonia several days to a week before the death. Necrotizing meaning that it was actually eating tissue in the lungs. And so as a result of bacterial infection, she became septicemic, resulting in all of this coagulation reflected in lab results, and that it was a combination of drugs suppressing respiration, and this was the phenergan or promethazine in two forms, suppository and cough syrup, and none of this other was mentioned at all anywhere in that.
And I know you're not a medical doctor, and I don't expect that you've memorized everything about this case, but do you recall the cause of death as testified to by the medical examiner?
She reviewed so little about it. She just referenced the triad of symptoms and shaken baby, and I can pull up what she said here.
My understanding, and I've not reviewed the record to the level that you have, but my understanding is that there's a certain designation when it is a shaken baby syndrome case, and it's not, it doesn't say shaken baby syndrome on the cause of death, and so I didn't know if you had that available.
No, I can probably find it for you, and I'll get it for you before I leave.
Okay. And if not, we can come back to it. What about as far as the defense attorney a while ago? You said that you would debate whether or not it was proper to bring this sexual assault back up, and would it also be proper to ask for a mistrial? I mean, based upon inflammatory assertions.
Absolutely. I would think that absent any evidence, any witness, no evidence whatsoever, I would think you could move for a mistrial, but that's certainly not in the record.
And then as far as if in your opinion, is the relief that, the best relief that could be granted would be by the Court of Criminal Appeals in the form of a new trial? Do you believe that that's the best case scenario?
Well, I certainly think at a minimum, there should be either an evidentiary hearing to show how this man's rights have been violated, and or a new trial, which I think would be pretty clear.
And would the two best pieces of evidence that you know of, would it be the CAT scan of the brain and also the photo that you showed earlier with regard to the child's lungs?
I think that, along with the history of her going into respiratory distress absent him being in her orbit. I mean, he wasn't in her life when this started happening. And listen, if I need to say, I work with the Innocence Project some, and for a number of years, and I've had cases brought to me that I look at, and I've been to death row and interviewed inmates and walked away and said, I'm not
Not feeling it.
not feeling it at all. I can't, in good conscience, say that I can get behind this. If I can't study the record and look the individual in the eye and passionately believe that there's been a miscarriage of justice, I just don't step up to them. So I don't get involved with everyone that's presented to me by a long shot. But when I see something like this, you can't walk away.
Well, thank you for being here today, and thank you for your testimony.
Chairman Leach.
Thank you, Chairman. Doctor, thank you for being here today. Just a few quick questions that I really want to focus and drive home with you, and I want us to try to take a step back together, because I don't know if you were able to hear some of our opening remarks, but I thought Representative Darby put it very well in his opening, in that we are not here. It is not our role as the legislature to retry this case. We have to be very cognizant and careful not to act as some sort of super appellate court. And I hear those concerns, I share those concerns, and we have to be, members, laser focused on staying in our lane. Does that make sense to you, Doctor? Of course.
Certainly.
Okay. So I want to be, this has been a very, very helpful, a very thorough and helpful overview, not only for the members of this committee, other legislators tuned in, the people here, but for all of those tuned in or watching online who are focused on this case. And I think the question that, as I seek to wrap my arms around this and think about the very purpose we're here, and I think about representing my constituents, Doctor, is I want to ask you this question. I think this is maybe what people who are tuned in right now are wondering the most. How does this happen? If everything you've said is accurate, and I believe that it is, in my own independent review of the record, everything you've said is 100% accurate, and there's a lot more that you haven't gotten to. How does this happen in our system? And if we're here to recognize holes in the system, weaknesses in the system, problems in the system, to strengthen our criminal justice system, Doctor, I would ask you to answer that question. How does this happen? Because to me, this is not a shaken baby case. This is an ineffective assistance of counsel case. And my hypothesis is that had Mr. Roberson had effective assistance of counsel, as he's constitutionally able to have, then we wouldn't be here today. Do you agree with that? And can you kind of can you go into more in depth on why this has happened and what we can do to fix it?
Well, I talked about what we did at CSI, for example, and some people might say that in America you're entitled to the best defense money can buy, and we did a lot of pro bono work. We either charge our fee or we charge nothing, because if you look at the population on death row, or you look at the population in prison, there's an overrepresentation of minorities. There's an overrepresentation of low socioeconomic.
Rich white guys don't get the death penalty, do they?
No, they don't. And they don't get a lot of prison time, either one. And so the fact of the matter is, when you get a public defender. And I know a lot of public defenders that are passionate, dedicated, and hardworking. And they got a stack of files on the corner of their
That's right.
desks that you can't even see over. And then I know some that are just, kind of checking the boxes. This is like everything else. There's a broad range, but I know a lot of dedicated, hardworking public defenders. But they're just so overworked and spread so thin that it's just impossible to give a fair representation to every client. But if you look at the number of exonerations, it's scary. You're either for the death penalty or not. And if you are for the death penalty, you have to be for doing everything in your power to ensure that those who face that ultimate sentence have had a fair trial and are guilty insofar as we can determine. I mean, you have to do everything. You can't kind of say sort of maybe we've got this right. And if 1107 says you can't do junk science, you can't have something that has evolved, and we're going to ignore that it's evolved and just use what was there at the time and keep them in jail, even though we now know better. If you execute people when you now know better, you need to abolish the death penalty. If that's the standard by which you're going to execute people, then you got a bad system.
So am I correct in assuming that Mr. Roberson could probably not afford CSI, correct?
Yeah, probably.
Okay, he couldn't. I mean, there's other, it's not casting aspersions on CSI.
No,
I've worked with
listen,
CSI before, and they're the best. But the point is that Mr. Roberson simply could not afford the resources to provide himself not only effective assistance of counsel, but the full assistance of counsel for a capital murder case in which the prosecutor decided, I believe, grossly negligently so, to seek the death penalty on. Mr. Roberson was afforded the minimal, and that's probably even being generous and putting it nicely, the minimal assistance of counsel. And in many cases, his counsel actually worked against his interests. And so my opinion is that he had virtually no counsel. And I, like you, and I think many members of this committee and other legislators, we get asked, Doctor, you might know this, but we get asked all the time. We get letters from inmates on death row. We get asked very frequently to review cases, to get involved, to speak out. Since I've been in office 12 years, I've received maybe over 100 of them. And I've only gotten involved in 3 death penalty cases. The case of Jeff Wood, the case of Melissa Lucio, and the case now of Robert Roberson. And without fail, in all 3 cases, it all comes back to ineffective assistance of counsel, because all of the facts that you've talked about here, all of these questions, all of the evidence that was not introduced at trial, the jury had no knowledge of it, members. None of that none of that is part of the appellate record. And so the system cannot work when it's built upon a foundational basis that all this evidence is not part of. So our courts of appeals can't review the evidence. The record is so defective. The case in and of itself is so defective. And so let me ask you this in closing. Do you believe that if Mr. Roberson is simply afforded a new trial, which is all I'm asking for, I believe that's all I don't want to speak for the members of the committee, but that's what I want, is just a new trial where maybe we could get him effective assistance of counsel and have someone like CSI prepare his defense and present all this evidence. Do you believe there's any way that he would be convicted of capital murder?
I do not. I do not think he would be convicted. I think this is a case where there was no crime committed. I don't think we have the wrong person. I don't think a crime was committed. I think this was a case where, tragically, a child was chronically and acutely ill. I think there was some problems with medication, and I think that contributed. But I certainly don't think that this child was aggressed against. But what I've said is, I, when you have a circumstantial case, we don't know what happened behind those closed doors. I can't say that with 100% accuracy. But I would be going beyond my skill set to say what happened behind that closed door. I don't know that. He woke up at 5 a.m. and says he found this child on the floor and with labored breathing because she'd been sick for quite a while. He says he was able to get her feeling okay and put her back to bed. Should he have taken her at 5? I wasn't there, didn't see her, don't know. But he testifies that she got to feeling better, and this wasn't a new thing. He had only had her for a couple of months, but you saw the record, 46 times across 2 years. Put her back to bed. Then he finds her again, and now he races her to the hospital. I don't know that any crime took place, and I think if this full record and the testimony from Dr. Green and other pathologists, I think they would say no crime was committed here at all.
Doctor, thanks for being here.
You do. Chairman Darby?
Excuse me. Dr. Field, thank you for coming today. Your testimony is invaluable to us. First of all, the name shaken baby syndrome. To me, that connotes guilt on the face of the charge. If you've been charged with shaken baby syndrome, it would indicate to me, at least, that somebody shook that baby to death. And since you were the last person to be near that child, that you were therefore guilty by simply being charged with the name. What are your thoughts on that? Whether psychologically to a jury, just being charged with shaken baby syndrome would indicate in the jury's mind that there was a crime committed, that you've now said perhaps was no crime. What are your thoughts on that?
Well, I think you're exactly right, Representative Darby. In psychology, we refer to something called iatrogenic label, where the label itself creates more problems than what it describes. And that is a very toxic label, obviously. And that's why I say I think sometimes burden of proof is a myth. When a jury hears something like that, they go, wow, if that's not what we're down here for, we have a dead child, and they're pointing fingers over here at this guy who doesn't seem to be terribly sensitive or upset. And if we're not down here for that, somebody needs to give me a really good alternative explanation, because they're looking over here. It's just like this setup right here. You got that big state seal up there and those flags beside it, and you got armed guards over here and all, and there's an awful lot of entrapments to this situation, trappings to this situation that make it seem awfully official. And then you got this guy over here, and the prosecutor knows the judge, and the judge knows the prosecutor, and they're calling each other by name, and the court clerk, and all is like, "Hi, Betty, how are you today?" And it's like everything seems against the guy that's there for the first time ever, and so there's a lot of momentum here. Somebody better have a really good alternative explanation, and there was a really good alternative explanation The only flaw was it never got mentioned. It never got told, which is why I made the point that jurors make decisions on what they see and hear, not on what they don't see and hear. All of this that I talked about today never got into the court record. It never got reported. Nobody ever put all those pieces together until 18 years later when the Innocence Project with pro bono lawyers and all come along and start piecing it together, and then they come to me, and I have my whole team at Merit TV, and everybody starts coming together, and now all of a sudden you have a valid defense team, and now you get an alternative explanation.
Well, I made a statement before you came into the chamber here, but the purpose of this body and committee, in my opinion, today is to examine our current law that's on record that we created. There was a problem when convicted people could not get their matter heard on appeal because there was not an avenue created by the legislature. We created it. And so in 2013, we addressed that deficiency. I'm going to be kind of a long question, but if you'll bear with me. We said that specific facts must be available that indicate relevant scientific evidence was currently available and was not available at the time of the conviction because the evidence was not discernible through reasonable diligence at the time of the trial, and the scientific evidence would be admissible under the Texas Rules of Evidence at a trial held on the date of the application. And finally, the court would have to find that if the scientific evidence had been presented at trial on a preponderance of the evidence, the person would not have been convicted. Okay. Now, that did not go far enough. So 2 years later, in 2015, we passed another law and said the courts would now consider whether the field of scientific knowledge, not junk science as we conveniently refer to it, we now refer to it as the field of scientific knowledge had changed. The court would also have to consider a new item, whether a testifying expert's scientific knowledge had changed. And so we created those standards. And what I'm trying to get to, did we go far enough or did we go too far? For example, it bothers me that the Court of Appeals seems to be taking a higher standard. They say that the evidence must reflect that the accused would be innocent. I don't think that's the standard by which we anticipated or created in 2013 and 2015. This almost, and several of the witnesses, I think they're going to testify again today, it's almost as though this habeas trial, it's kind of like a game of football. You're going to win or lose. I mean, instead of trying to determine, in your words, the goal is to seek justice, it doesn't appear that the functionality that we've created in the Court of Appeals is designed to seek justice, or is it simply designed to see who wins and loses? That's what's bothersome to me. If we created language that would suggest the Court of Appeals is saying, no, that evidence has to show the accused is innocent, when I don't think when we voted for this bill in 2015, 2013, that was a level of examination that I don't think we created. So I guess ultimately I'll come to a question. The question is, do you think that our current law for scientific knowledge has changed, and whether or not we had an expert testify, not changed his testimony, saying that he believes he wasn't innocent. I mean, he wasn't guilty. Do you think our current, and I've given you the factors that compose what we're trying to address here, is that science has changed. Do you believe that we followed that law, or the Court of Appeals has followed that law? And if not, what should we include in statute that will assure that following?
Well, I can answer that. Can I answer that in two parts?
Sure.
One is, I think it needs, whatever it is, needs to be followed evenly. I believe it's the Roark case that um, last week or the week before, um, a new trial was granted, correct? But in this one, it's not. So, I mean, it seems to me like it needs to be evenly applied. Um, so I'm wondering, how do you explain that to Mr. Roberson's family? And then secondly, I think there's some simple language that might help. And now, I'm not a lawyer. I don't mean to brag, but I'm not. Um, if you added something to it that said, in the event the filing is on behalf of a convicted person to be executed, the court shall stay the execution and grant the convicted person a new trial if the relevant scientific evidence was not available to the convicted person in light of his or her circumstances, and/or that relevant scientific evidence contradicts scientific evidence relied upon by the state at trial. So if it's evolved and it wasn't available at the time, they ought to get the best science available that bears on their conviction. It seems to me when they're executed for a long time. And you see something as clear as the case I cited earlier about Mr. Byrd. It took from 97 to 2019 to execute one of those perpetrators. In a circumstantial case, how can you not justify saying science has evolved? They get the current science, which is what this says, and I'm happy to share this if anybody wants it. It just says they get the current science.
Well, thank you for your testimony.
Representative Bowers. Oh, I will follow up with you, Dr., and take you up on that offer to submit that to the committee.
I will.
Representative Bowers.
Thank you, Mr. Chairman, and thank you, Dr. Phil, for being here today. I am certainly a fan, and I know that your show was a spinoff from Oprah, so I'm certainly a fan. Been a fan for a long time, and I will say to you that I am glad to have this privilege to ask you some questions because we know you ask the hard questions. You mentioned that a little bit ago, and before I get to my question, my pastor, Richie Butler, said to tell you hello and that let you know he's my pastor. But I'm so glad I get to ask you the questions and I didn't get called to your show for you to ask me.
Fair enough.
But I want you, if you can, to take us back, and I promise you I will watch it. I have not watched the interview with Robert Roberson, but can you take us back to that time when you did have a chance to talk to him, since we won't get to hear from him today in this chamber? And I just want to know, because you mentioned, and we heard this before, that he was very flat in his responses, and we do know that he's on the spectrum. So I just wanted to know if you can share a little bit more about that time and moment and what those answers, because you said you asked him some pretty hard questions, and what his responses were like, and what, was there remorse there? How did those responses come out? I would just like to hear a little bit more about that.
Yes, I will. When I sat down with him, the Pulaski unit is one of the best run units in the United States, I have to say. And I've been to many prisons and talked to many convicted murderers, and that unit is I have to say, it's really well done. Um, they, they treat their prisoners with dignity and respect, and um, they, they do things the right way there. And when I'm permitted to come in, I respect their rules as well, because everything runs, order is really important to keep everything running the way it should. And when they tell you that you're going to have an hour, I really try to respect that. And so I sat down with him in the beginning and said, listen, we're on a time clock, so I'm going to forego a lot of small talk and jump right into this if it's okay with you. And he said, certainly. So we jumped right into it. And I said, you're days away from being executed. And I, I want to know how you feel about this. And I started asking him about things. And I asked him some things like, are you bitter? How do you feel about this? Are you angry? Are you bitter? How do you feel? And, and I'm spending as much time hearing what isn't said as what is said, how he's answering, and what his eye contact is. And he's very, still, he's very flat and very robotic. And he says he's not bitter at this point. It's been 21 years, and I guess you can stay angry for just so long. And he says he's really not, and he spends a lot of time in his Bible and reading the Word. And I asked him, I said, you've been in trouble before. Tell me about those sort of things. I wanted to see if he tried to deflect or minimize those things. He was very forthcoming about it. He said that he had gotten into drugs at one time, and that caused him to make a lot of bad choices, and he got in trouble for it and seemed to feel like he should have, that he did things he shouldn't do, violated his probation, and got time added to that for it. And again, he didn't try to minimize or whatever. He was straight up about that. I asked him about his relationship with Nikki, and he said that he had only been around her for a couple of months, and that she was pretty standoffish with him and seemed to kind of be afraid of him, but that they had started to break that down some, and that there was some warmth, and she started to sit in his lap and let him hold her and that sort of thing. I asked him what he did when he was angry, for example. He said he went off by himself and spent time alone. I asked him if he ever put his fist through a wall or slammed doors or broke things or pushed people or yelled and screamed and whatever. And he said, I just kind of go off by myself. I don't, whatever. I gave him some cognitive challenges. I asked him some simple things. Like I asked him, interpret this saying for me, shallow brooks are noisy. He had no idea. I said, still waters run deep. How about that? No idea. I said, if I gave you a screwdriver, a flat screwdriver, you could screw a screw in and screw a screw out with it. What else could you do with it? Couldn't think of one other thing you could do with a screwdriver. Nothing. I gave him some items to remember and asked him to recall those, not after an hour, but after about 15 minutes. I think he got 1 out of 5. And so he was having trouble. Of course, he's under a lot of stress too, and that doesn't help. And then as I asked him straight up, did you hurt this child? And I really watched him, and his blink rate's about 12, 13 per minute. You go under stress, if you ask a relevant question, people are lying that blink rate will often go to 70 or 80 in a hurry. He didn't change at all. He didn't color up. He didn't stutter or start, changing his patterns at all. Just no, no, and no. And I asked him if he thought he had a fair trial, and he said no. His lawyer kept saying, shaking baby, and I told him, why are you doing that? That's not true. I don't want you saying that. But he said, well, I'm trying to save you from first-degree murder. That's what they're charging you with. But he said, well, I don't want you saying that. He said, well, just, sit down. And he was very hopeful that he was going to get some kind of relief here and not be executed. And he thinks he deserves to be free.
Thank you for that. And thank you for giving us a snapshot of what that interview was like. And I certainly will be going back to look at it and view it. But and thank you for asking him questions, like you said, the hard questions, but then certainly some simple questions. So and sharing that with us. I really appreciate it. And I have to say, I'm so glad to be on asking you the questions.
Thank you.
Thank you, sir.
Yes,
Thank
ma'am.
you.
Representative Schatzline.
Thank you, Chairman. Dr. Phil, thank you for being here.
You bet.
I said this at the last hearing, and I'm going to keep saying it as loud as I possibly can, and that is that justice that requires unsubstantiated assumption is not justice at all. And I think that's what's so valid about you being here and you doing that interview. Thank you for using your platform to get truth out. And so I had a few shotgun questions for you, just to get a 5,000-foot view of anyone who is watching. You said that juries decide this on what they see and hear, not what they don't see and hear. Did the jury know that Nikki had been chronically ill her entire life?
No.
Did the jury know that she had 2 recent episodes of a sudden halt to her breathing, or we would call it breathing apnea?
No.
Did the jury know that she was brought into the hospital with 104-degree fever?
I don't believe that was in the record.
Did the jury know that one of the drugs that was given to Nikki is no longer used on children and has a black label because it makes it difficult to breathe for children?
No.
Did the jury know that she had been diagnosed with bacterial pneumonia?
No.
And you mentioned that Robert was not perfect and in some ways had a troubled past. And I think it's important to point out, because we're talking about an execution, a state-sanctioned execution. To your knowledge, has Robert ever been convicted of a violent offense before or after this trial?
It's not that we've been able to find. We've seen the burglary and the drugs, but no violent crimes, no assault, no mugging, no assault with a deadly weapon, nothing like that.
Right.
We've not been able to find anything like that.
Right. I would agree with you. So even though a jury that's never gotten to hear any of these details, is it possible that the bacterial pneumonia mixed with a combination of dangerous drugs, some of which are no longer available for children because they're deadly, mixed with a fall off the bed, is it possible that these factors alone could be the cause of death?
Well, according to, again, I'm not a physician, but I can read, and according to the pathologists that have reviewed this now, definitely conclude that that is a viable cause of death for a vulnerable child that had chronic pneumonia and was septicemic.
So with that being said, do you believe that the junk science law has been violated in Robert's case?
Well, I think it clearly has, and I think there are a number of exonerations in very parallel cases to substantiate that. And again, I don't want to get out of my lane. I'm reporting to you what the research says. I am not a physician. So I'm telling you what the physicians that have been brought into this case are reporting and what the medical research that's available to anyone that can read reports, and what other cases that are a list of exonerations that I can share with you. Exonerations have taken place where they've determined that no crime was committed at all because of exactly the things you're listing out.
Yes, I agree with you. In fact, the number that you're talking about is 32 exonerations that we've been able to find of those that were convicted of shaken baby syndrome. And so you said that the death penalty hangs in the balance here, and I agree with you. So is it your opinion that a reconsideration by the Criminal Court of Appeals and giving Robert a retrial actually strengthens the legitimacy of the death penalty in the state of Texas?
Well, I think it does. I think there's been over 5,000 years of time on death row served by innocent people that were ultimately exonerated. So, and Texas is second only to Illinois in the number of exonerations. So we need to get this right. If we're going to preserve the death penalty, we need to show a commitment to do everything possible to get it right. And if we're not good stewards of that, then we shouldn't have the privilege of asserting it. So if we want to preserve it, we need to be really committed to getting it right.
I couldn't agree with you more. As a member who is supportive of the death penalty, I also believe that if we are going to execute people in the state of Texas, we have to be sure at the highest level that we can that that person committed this crime. As someone who wants to fight for individual liberties, this is something that has to be at the forefront of our mind. And I couldn't agree with you more that this actually, a retrial would strengthen the position that the death penalty should be a viable option for the courts in the state of Texas. Thank you for your testimony.
Thank you.
Representative Bojani.
Thank you. Thank you, Chairman, Vice Chairman. Thank you, Dr. Phil, for being here and for letting the committee know numerous issues, including the tunnel vision in trials. That is the focus too narrowly on one explanation, which happened to be here, shaken baby syndrome. What changes would you suggest to prevent this kind of confirmation bias from affecting investigations and trials in the future?
Well, I think there has to be some focus on being sure that we aren't looking over our shoulders and doing what's historically been done. But if we get into a situation, somebody has to be willing to step up and say, where are we now? Things are changing at a really rapid rate. We're learning so much more about how things are happening, and medical science is advancing, as is we've seen it with DNA. We're seeing it with shaken baby syndrome. We're seeing it across a lot of different fields. So we just need to be sure that our prosecutors are really held to a standard of looking at where science is in a given area in circumstantial cases. And I say circumstantial cases because nobody was there that morning, so they have to look at all the circumstantial cases. And I also want to say that the people at the hospital that morning who waved a red flag and said, hey, we need to take a look at this, were not wrong. When somebody shows up with a baby that is in distress like that, and you've got somebody standing there and they don't seem terribly concerned about it and all, look, those are social worker, psychological red flags. And somebody should pay attention to that, because oftentimes they would be exactly right. There's a lot of abuse that happens with children. And somebody, I would rather be wrong 99 times than miss one for sure. So I do not fault those people for asking that question and saying, hey, time out, let's see what's going on here. But asking the question and going down a tunnel vision and snowballing somebody to death row are two different things. Somewhere along there where you ask the question That's valid. But then not saying, okay, but let's wait a minute here. Let's ask all the questions. What's this child's medical history? We've got a lung scan. They didn't wait for the lung scan before they determined it was shaken baby syndrome. They called for a brain scan and a lung scan and did not wait for the results before they decided what they were going to do. And that's my problem. My problem is not with them saying, hey, red flags here, we need to start asking some questions. Not a problem with that. The problem is they didn't follow up on available science to determine whether or not this was a chronically and acutely ill child. This child was septicemic. This child had chronic pneumonia, and there were scans done that they didn't take into account. Not even the medical examiner took them into account. The medical examiner admitted a list of things that were not looked at. That's the problem. If you're going to see the red flags, and you should, then make sure you check all of the different areas that you can get data from.
Got it. Thank you. One more quick question. I know there are a lot of people here that are listening in that care about, people live with autism. So in future cases, how can we ensure that individuals with autism spectrum disorder receive appropriate accommodations during the trial and post-trial proceedings? They are treated fairly and their needs are fully considered in the justice system?
Well, this was not diagnosed until 2018, so no one gave Mr. Roberson the opportunity to be evaluated, and I think I did not see him 21 years ago, but I can tell you in spending time with him, and I just spent an hour with him, I cannot diagnose this individual in an hour through a glass and all that. So, but I can tell you this, we're talking about red flags. In the hour I spent talking with him, questions were going off in my mind about his ability to assist in his own defense. And if he was anywhere near that level of functioning 22 years ago, someone should have stepped up and said, this individual needs to be evaluated, and the state needs to do that. And I don't know what that evaluation would have shown. I can't. All I know is that I've seen the report that he is on the spectrum at this point, and all, but I can't diagnose him, but I can tell you big red flags were going off when he couldn't, he was not showing the cognitive agility or the reasoning that I would have thought you would want to assist in your defense. And so I would have thought an advocate would have been really nice to have him at his side during that trial. And the autism community now is so great in assisting those. But I think that he needed to be evaluated at the time.
Thank you.
Representative Harrison, did you have any questions?
Yeah, just a couple quick ones. You've covered this rather extensively. Thank you so much for that. I just want to go back to a couple things. One, from your previous discussion with Chairman Moody on something that I found concerning, and I'd like you to maybe clarify some of your previous remarks with him, because I have been surprised to see over the last few days the state now start making assertions that that the prosecution was not predicated on a shaken baby syndrome hypothesis, and that in fact this was not that, but that this was effectively a battery case, and that this child had been beaten. How would you characterize those representations that we are now hearing from the state?
Well, I think a careful analysis of the trial record would suggest otherwise. I think all you have to do is look at the trial record and go through and look at their arguments, and they tried to shake a baby case. I mean, if nothing other than the defense voir diring the jury on shake a baby, doing an opening statement on Shaken Baby and doing a closing argument on Shaken Baby. That's certainly what they were defending. If nothing more than his own representation, it was a Shaken Baby case.
And that's absolutely consistent with my examination of the record in this case. And what it was one of the early things that struck me, and tell me if I'm wrong here, if I'm oversimplifying this, I want to get it right. You effectively had a case where the state, the prosecution, was arguing shaken baby syndrome. And the defense attorney, his counsel, said, and I believe it's a direct quote, "Yep, classic shaken baby case." And given that 20 years ago you could presume abuse, what was left for the jury exactly to decide?
Yeah, it was just, I think the argument from the defense was it didn't rise to the level of first-degree murder that he snapped, or it wasn't premeditated or whatever, just he lost it in the moment.
So was there any arguments or evidence that the jury heard that this was not a shaken baby case?
I think there were other things that went along with it, that there were bruises on the left side of the face, to the jaw and to the chin, and multiple trauma to the head. But I think that you have to break it down and say, well, when was the trauma to the head? Because from admission to the hospital to the time the pathologist got involved, there were other insults to the head in life-saving efforts where you try to do things to relieve pressure off the brain, but those weren't there when the baby came in. They were done when they started doing things to try to relieve the pressure.
Right. So how much time to those things that you said that were related things that kind of were brought up, how much time at the trial was spent explaining to the jury any alternative explanations for either the shaken baby triad or for the other things that were observed on the baby?
None that I could find.
Yeah, none. So was there, is it fair to say that there was, or I'll ask it, was there direct evidence of abuse at trial at all, or was it all circumstantial?
It was all circumstantial. Well, it was all circumstantial or reported by witnesses who later impeached themselves by saying, I was coerced into saying this with threats from Child Protective Services or implied threats from Child Protective Services or whatever, that changed their testimony.
I hear a lot of people out there right now saying, we should just trust the jury. They convicted him. In your opinion, is it even a debatable question whether or not the jury had all the evidence necessary to make such a decision?
Well, I have to answer that two ways, Representative Harrison. I think jurors tend to get it right. Day in and day out, I think jurors tend to get it right based on what they see and hear.
Correct.
Based on what they see and hear, I think the collective IQ of a jury is 1,200. I think you send them back into a room. I think most people take it seriously. I think they put their heart into it, and I think they get it right based on what they see and hear. And I think they probably got it right in this case based on what they saw and heard. But they didn't see and hear everything they needed to see and hear to render a just verdict.
Do you think that's even a debatable question?
Not even close.
Yeah. If I can dig in real quick on something you just said, you mentioned that witnesses that may have impeached themselves. Can you give is there a particular example or a particular witness that you're thinking of?
Well, yeah.
If there's not, it's okay.
No, it's okay. There are witnesses that testified at trial, and they were witnesses from his past, and
and the reason I actually asked, because Representative Schatzline a minute ago had made a question about, whether there were substantiated or unsubstantiated discussion of violent behavior in the past that came out at trial.
Yeah. page 12 of the main document. Okay, got it. Let me turn to it here. Teddy Cox, who was Robert's girlfriend at the time, she was going to be the subject of a CPS investigation, so she was urged to provide information to implicate Robert, and was confined to a psych ward and admitted on the stand that she changed what she said about Robert based on how she felt at the time. But rebuttal witness Patricia Conklin, Teddy's sister, said Robert had a loving relationship with Nikki, never saw Robert spank Nikki, and Teddy had a poor reputation for truthfulness.
And this was one of the individuals that testified, that provided the witness testimony that I keep hearing about all over the place on social media, that there was evidence that he was a violent person.
Yes, Della Gray, his ex-wife and mother of his two older children, said that he was physically abusive, but interestingly enough, said she was scared of Robert, but during their divorce proceedings never reported any of this suspected abuse to authorities, and had a history of alcohol and drug abuse, and she lost custody of the children and never brought any of this out. She claimed in a 2003 trial during their divorce proceedings in the 1990s. So you kind of have to look at what they said at the time versus what they said when they had an agenda. So I think these witnesses, when they were looked at as to their motives and or were asked hard questions, tended to change their.
So to the best of your
testimony.
knowledge, no jury has ever found him guilty of any violent acts in the past that you're
No,
aware
he's
of?
been accused of it by people that had an axe to grind, but no evidence to substantiate it.
Real quick, as brief as you can, how would you characterize the effect on our criminal justice system if Robert is executed in the near future?
I think it would, I think if people really drilled down on the facts of this case and thought, given these facts, you can be executed against a standard of reasonable doubt, I think it would be horrifying.
Horrifying. The impact on our criminal justice system if he's executed without further due process being afforded him. Is that
Yes.
what you're saying?
Yes, I don't think he's had due process, and I don't think he's had a fair trial. And I think he should. And if at the end of all of this being presented, the decision is that he's guilty and should be executed, then that's a completely different story. But I think it should all be heard.
And I'll just, in closing, if you could maybe just even one or two words, if you can, and just tell us whether you think these are more fact or more opinion, because I know you've made a point to distinguish what you believe is fact in the case from opinion. Do you believe our junk science law, as intended by the legislature, has been appropriately applied in Mr. Roberson's case?
I do not.
How firmly do you feel about that?
I feel very strongly about that because the science has evolved and we have cutting-edge experts in this case that have taken very strong positions that the cause of death in this case, is more probable from medical complications than abuse.
And if I wrote down my notes, but just a quick confirmation, you firmly believe his due process rights have not been adhered to here, and how confident are you of that?
I'm very confident that due process can only be claimed if he is given an evidentiary hearing, which will lead to a new trial.
And if I wrote down correctly a minute ago, did I hear you correct that in this case, your personal opinion is that no crime has been committed whatsoever?
Based on the new evidence from the experts, I think no crime has been committed here.
Thank you, Doctor. Thank you, Chair. Thanks for being here.
Doctor, I appreciate your time. And you know what? I want to say this also. I appreciate your extensive research into the record in your preparation for your testimony here today. I appreciate you taking this with a great deal of seriousness that we are evaluating what happened here. And for us to be able to evaluate that, we do need to rely on people that have done a deep dive into things. And I am grateful that you have taken the time, energy, and effort, you and your team, to do that deep dive, because you wouldn't be able to answer any of these questions if you hadn't have done that research.
Well, I have this knack for getting gigs where somebody does all the work and I get all the credit. And Stephanie Grenadier and her team at Merit TV and the Innocence Project and all of their people, we've all worked very hard to figure this out. And most of it was done before I agreed to take on the case, because I had to figure out whether this was someone that I could passionately get behind.
Well, I certainly appreciate the time you put into it, and I think that that is certainly shown through in your testimony today.
Well, I appreciate the committee, and if I've kind of been doing this off the top of my head here as we've gone through this, and if I've misspoken or misstated any fact, it's all in the record here, and I'll correct it as if I check anything. If I got a date wrong or something like that, I'll certainly correct it. The record is what it is. The trial record is what it is. If I said 4 and meant 5 or whatever, I'll let the record speak for itself. Certainly what I've said is directionally correct.
Well, we certainly appreciate your time and taking so much of your day to be with us here today.
Well, thank all of you for taking this so seriously and speaking up for, this is not just about this man, it's about the process. And I hope it comes to a good outcome. Thank you for allowing me to speak here. It's an honor.
Thank you. This time, the chair calls John Grisham. All right, let's see. Bullet. Mr. Grisham, are you able to hear me?
I can hear you. Yes, can you hear me?
Okay, perfect. All right, and now we can actually see you as well. Sir, my name is Joe Moody. I'm the chair of this committee. I appreciate your accepting an invitation to offer testimony here today. So they certainly want to be respectful of your time. Before we start, I do have to, just as a matter of housekeeping, I have you listed as John Grisham, representing yourself today and testifying neutral on the item before us. Is that correct?
Yes, I guess I'm neutral. I don't feel too neutral, but I'll say neutral.
I'll be very clear. I don't anticipate you are very neutral in this matter whatsoever. But because there's no actual piece of legislation before us, you're technically, every witness that's testifying before us is neutral. So not to get into the mechanics of it, but I appreciate that. So with that being said, that all is correct?
Yes, that's all correct, yes.
All right, then I don't want to take too much time on the front end. I know members might have questions once we hear from your testimony. I certainly know that the committee is specifically interested in how you got involved in Mr.
Sure.
Roberson's case.
Sure.
Maybe some of your background, your experience as a trial lawyer, how you've interacted with other issues related to wrongful convictions, and ultimately got involved here, and anything else obviously that you want to offer. We'd appreciate that. Thank you, sir, and I'll turn it over to you.
Well, sure, Chair Joe Moody and members of the Committee on Criminal Jurisprudence, thanks for the invitation to be here and say a few words. I wish I could be there. It's much more effective, and Austin's one of my favorite cities. I apologize for not having prepared remarks. I'm on a book tour. I don't work that much, but I'm working this time of the year when I publish. So I've been on a lot of airplanes. I just got to New York, and so I'll just ramble for a few minutes and then take some questions. I sort of know what you're doing because years ago, I was a member of the House Judiciary Committee in the Mississippi House of Representatives, and I had that for 2 terms, and we had a number of committee hearings, as you do. I don't miss any of them. So I sort of know what you're going through, what you're doing. But none of those hearings back then were nearly as important as this one right here. So it's my honor to be here to speak for Robert Roberson. I'm also honored to be here to offer a few words of great admiration to this committee for your actions last week. You literally saved an innocent man's life. You took a bold stand against injustice at the precise moment when the courts and the leaders of the state seemed hell-bent on executing Robert. If not for you, Robert would be in his grave today. Your actions were creative, to say the least, fascinating, unique, courageous, bipartisan, and heroic. And we all watched in disbelief last Thursday night, not just in Texas, but around the country, around the world. I've talked to journalists in Europe the past few days doing book stuff, and they are fascinated by this case and by the actions that this committee took last week. So you chose to dig deep and to find the truth and recognize that Robert's life was worth fighting for. So I'm honored to be here to meet you. Robert doesn't need me to speak for himself. He has as you know by now, a great legal team made up of lawyers from Texas, Washington, and New York who have worked for many years to prove his innocence. One of those lawyers is a friend of mine in Washington, and about 8 months ago, he asked me to take a look at the case with the idea of perhaps writing an op-ed piece for a major newspaper. And I said, sure. I've been on the board of the Innocence Project in New York for a long, long time. And for the past 15 years or so, we have been more and more concerned about the shaken baby syndrome, shaken baby convictions. It's something we have studied. So I was somewhat familiar with that problem. And I said, sure, I'll take a look. My understanding is that last week you guys you committee members got a lot of testimony about the medical and scientific evidence now available that proves that Nikki did not die because she was shaken to death by anyone. She died because of viral pneumonia, and we can prove that. I'm not a scientist. I'm not a doctor. I'm a lawyer, and I practiced criminal law in a small town in Mississippi for 10 years, and I had a lot of cases, a lot of clients, a lot of jury trials. I tried over 100 jury trials in 10 years, and I came to really respect the idea. We just believed in the idea of a fair trial. We still do. All Americans believe in the idea of a fair trial. We at least pay lip service to that. And I never had a client in 10 years I thought was wrongfully convicted. I knew the judges, the prosecutors, the policemen, the game was played fairly. And I just never thought about wrongful convictions until I'd written probably 20 books. And I saw this case that out of Oklahoma that fascinated me about a man my age who went to death row and came within 5 days of being executed. And so I wrote my first nonfiction book, The Innocent Man, published in 2006, about Ron Williamson and what happened to him. And it was a fascinating entry into the world of wrongful convictions. I have since become convinced that there are a lot of innocent people in prison. And that's why I do this work. That's why I get involved in these cases. As a lawyer, it always bothers me when I study a case like this and I realize how unfair the trial was. Because I've been in those courtrooms many times, and I know what it takes to have a fair trial. Robert's trial was grossly unfair. There was nothing aside from the junk science. The science was terrible. The science has been debunked and discredited and disproven now for the past 15 years. We know it's bad science. The science was terrible. The jury selection was awful. From the opening bell, the prosecutor was allowed to point a finger at Robert and call him a baby killer or whatever. That persisted throughout the trial until the closing argument. The absolute low point in the trial was when a ER nurse was allowed to testify that Nikki, who had been sick for her whole life, but really sick the week before she died, she had violent diarrhea, fevers, upset stomach, everything. A nurse was allowed to testify that she saw signs of sexual abuse looking at the child's anus, and there was no allegation of sexual abuse anywhere. It was not proven by the autopsy. There was nothing there, but she was allowed to testify. When I was the defense lawyers, to their credit, objected. When I was a lawyer, that would have been grounds for an automatic mistrial. There's no way a prosecutor could get by with that in most courtrooms throughout the country. That's a mistrial. You stop right then and you say, stop it. And the jury goes home and you try again. That didn't happen. The judge waved it through. And the prosecutor was allowed to keep using the sexual abuse language even in his closing argument. The trial was a farce. It was a pathetic trial. And that's what I go back to in these cases. If we could go back and get a fair trial, and I think that's all Robert and his lawyers would love right now, is to get back into court, have the CCA declare a new trial. Let's go back to Palestine, Texas, to Anderson County, or maybe change venue, whatever. And let's have a legal team that Robert can have with as many lawyers as the prosecution, as many experts as the prosecution, as much money as the prosecution. Put the jury in the box, and let's have a fair trial. That's all we're asking for. I'll stop rambling now. I just listened to Dr. Phil, and I'm astonished at the amount of research he and his staff put together in preparation. It was truly remarkable. I'm not that well versed in the case. I've come to it lately, but I'll try to answer any questions you may have.
Well, Mr. Grisham, I certainly appreciate that. I know you've looked at some of this from a nationwide level, right? These wrongful convictions and some of that you've been able to delve into. Are there trends that you see, problems that emerge, things that would be helpful for the committee to understand that you've seen in your broad brushstrokes over this issue nationwide?
Sure. I mean, you start with junk science. With the Innocence Project, we have, I think our number is 370 or 375, around that, DNA exonerations in the past 30 years. These are clear-cut DNA cases where they got the wrong guy. We were able to exonerate, which is not always easy, even with DNA testing that you pass. But in those cases where we have the exonerations, junk science is prevalent in half the cases. And it's excuse me, hang on. It's the bad analysis. It's like bite mark analysis, hair analysis, boot print analysis, arson analysis, and shaken baby. It's just more, there's so much junk science in our courtrooms and have been for the past 50 years. Unqualified experts giving opinions that are not driven by science. So junk science is a huge factor. There are many other factors that lead to wrongful convictions. Most of them are not present in Robert's case. And in some cases, you have everything. You have the lying jailhouse snitch, the paid informant, you have false confessions, you have incompetent defense lawyers. There's a long, sad list of reasons for wrongful convictions, but junk science is by far probably the biggest factor that we could do something about. And Texas has done a wonderful job with the commissions founded in 2005, with the law you passed in 2013, the amendment in 2015. Texas is at the forefront of cleaning up the forensics. I wish all states were doing that.
I appreciate it. I think that's we've seen a little bit of that. We've done some research into, in fact, we did some research after the death of Timothy Cole here in Texas on wrongful convictions and what kind of some of the common threads were in those cases, so that we could start to address them. Obviously, junk science was addressed in particular in this provision, and so I think those are some very good points that everybody can take forward. I do want to make sure, and I want to respect your time. I know we've got a limited time to visit with you, but I want to make sure if there's anybody have questions, I don't want to monopolize the short time that we have to visit with you. Anybody down here? No? Over here. Then I will, well, actually, I have a lot I want to go into about DNA cases. I want to be respectful of your time to make sure that, oh, sorry. Yes. Sorry, I do have a question. Chairman Leach?
Yeah, thank you. Thank you, Chairman Moody. Mr. Grisham, thank you for joining us. Let me just ask you one question. And I've read a number of your books, and Mr. Grisham actually decided to go to law school myself and become a lawyer, largely because of so much of what I've learned and gleaned about the practice of law and the importance of honest and good and knowledgeable and passionate lawyers on both sides. Can I just ask you, as someone who sees the legal landscape nationwide, and you've written about, you've researched, you know a lot about these cases, you've committed yourself to the wrongful convictions and making those right. What do you think it's going to take, understanding where we are right now in this case? What if you were us and you're trying to make the case to the other branches of government to give Mr. Roberson a new trial? What would you focus on? What to you are the most troubling aspects of this case? And what's it going to take, in your opinion, to get to achieve justice for Mr. Roberson?
Well, I hope it's not a disaster. I hope it doesn't take a wrongful execution. We do not, to my knowledge, we do not yet have a case involving clear DNA proof that we've killed the wrong person. The Death Penalty Information Center tracks all types of data for wrongful convictions and for death penalty cases, and they list about, on their website, they list about 20 cases of probable innocence. Okay, half of them are from Texas. These are probable. You can't really prove them. Okay, they're close. There's no DNA case. And so years ago, I wrote a book about the premise was, what are we going to do as a nation when we wake up one day and we know by clear DNA proof we just killed the wrong guy? That's a great question. I can't answer it. I don't know. I'm afraid we won't do much at all. I am encouraged by the declining number of death verdicts around the country, the declining number of executions, and the number of states that are outlawing the death penalty. That's a good sign. I tell my friends all the time, people who, I grew up in supporting the death penalty because I grew up, in Mississippi, Southern Baptist and all that. I tell people all the time who support the death penalty, you can't support this death penalty, but I can show you how to make one fair if you want to make it fair for everybody. And keep in mind, most capital murder defendants are guilty. The crimes are horrible. But there are too many innocent ones.
Mr. Grisham, would you agree though, and that's one area on which you and I might well, we definitely do disagree, because I myself am a death penalty supporter in the most heinous cases, much like Dr. Phil described earlier. But like Dr. Phil, and I think like you, and hopefully all of us, we can agree that the worst thing we could do for our criminal justice system is to execute someone who's potentially innocent. Certainly someone who's definitely innocent, but even someone who is potentially innocent with such substantial questions in a case such as this, wouldn't you agree that pushing the pause button and going back and simply affording a new trial in front of an unbiased trier of fact so all of the evidence can be heard, wouldn't you agree that is the only right option?
Yes, especially in a case like this one, where the science has changed. Now, not all cases have this. Not all cases have, science has changed so much, or science has been discredited or proven to be not correct. But when you have a case like this where the science is just wrong, okay, it was wrong 30, 40, 50 years ago when it was first developed. Sure, you have to go back to a fair trial. Let's do it all over again. Well, what's the hurry?
Right. Thank you, Mr. Grisham. Appreciate your time today.
Thank you.
And before I let you go, I think about this because DNA becomes kind of the gold standard in exonerations. I mean, when we have actual innocence cases in Texas, that's kind of, we require that to be part of the combination of factors that's considered. If we don't have that, then you don't get to the actual innocence piece. Like, we feel so strongly about DNA evidence and its reliability. That's the weight we give it. But in many of those cases, in fact, I'll just ask you, I mean, you've looked at cases that were later ended in exonerations via DNA evidence. In those cases, prior to the DNA exonerating that individual, weren't there people crying out loud that this individual is still guilty, they're guilty of sin, they did this, they're adamant about the guilt of this individual, and then later DNA evidence comes out and exonerates them?
Happens all the time. And we worship DNA. However, in most murder cases, there's no DNA. There's no body fluids. There's nothing left behind it. So you have to go back to other forensics, ballistics, or identification, or whatever. Most cases don't have DNA testing available. So those are much more difficult cases to exonerate than DNA. DNA has been a lifesaver, and the police are using DNA more and more to solve crimes, to their credit.
Well, and I think you made the point I was trying to make, which is, if people will shout from the rafters that this person's still guilty over and over, and then DNA later exonerates them, but DNA is such a limited number of cases, it reasons to follow that in non-DNA cases, there are people still shouting that this person's still guilty, but in fact, they probably are not. I mean, yeah. Those have to correlate. They have to correspond. We have such rare opportunity to have DNA evidence, which we all have a great deal of respect for, but all of these other cases you just stated don't have that. And so, that's where a lot of this type of procedural law comes in to help. alleviate those gaps where we don't have the gold standard like DNA. So I'm certainly grateful for your time, and I want to make sure none of the other members have questions. Want to be respectful of your calendar. And do we have any more? No, Mr. Grisham, thank you so much, and thank you for taking the time.
Thank you very much.
Thank you. Chair now calls Terry Compton. Sorry. She'll be. Good afternoon, Ms. Compton.
Good afternoon.
Let's do this. These are fairly directional mics, so for us to be able to hear you,
Bit
you gotta,
closer,
yeah, if you can actually pull the whole microphone up to you. That'll work real well.
like that.
Yeah, that'll be perfect. Before I have you testify, just want to make sure I have this correct. Your name is Terry Compton.
Yes.
You're here testifying on behalf of yourself, correct?
Yes.
Okay, and you checked that you are neutral on the topic today.
Yes.
Okay. Do you have prepared remarks for the committee today?
Yes.
And then, you know what? I'm going to let you start with that, and then we'll ask some follow-up questions if we have them.
Okay.
Thank you for being here. Let me ask you this. When did you get into Austin?
About 11:30,
And where'd you come from?
Palestine, Texas.
Okay. Well, I want to say thank you for taking the time to be here with us today, and I will let you give your comment. Thank you.
Okay, thank you. Good afternoon, everyone. It is a great honor to be here testifying before this committee. My name is Terry Compton. I was one of the 12 jurors on the case of Robert Roberson's trial, and I took that position very seriously. Everything that was presented to us was all about shaken baby syndrome. That is what our decision was based on. Nothing else was ever mentioned or presented to us to consider. If it had been told to us, I would have had a different opinion, and I would have found him not guilty.
I, first of all, want to thank you for being here. And I know it was not an easy thing for you to get here. I know you have a lot of obligations back home. So I'm grateful for the time you spent. I know that Mr. Harrison had some questions for you, and I know some of the other members have questions for you, if that's okay. But I'm going to allow him to ask you questions first, if that's okay with you.
Yes, sir.
Okay, Representative Harrison.
Thank you, Chairman. And Terry, thank you for being here. You drove a little ways to get here, and
Yeah.
my understanding is you've got a pretty busy life on the home front. Tell us just a couple sentences about that.
Yes, sir. I raised 3 kids of my own, and I have multiple grandkids, and then I ended up having to adopt my 4 youngest grandkids, and I am now raising them. We adopted them, me and my husband. My husband is 86 years old and has multiple heart problems and stuff. He has an LVAD on his heart to where his heart is being pumped off of batteries. I am 69, so having to take in a 13-year-old, 11-year-old, a 7-year-old, and a 5-year-old the younger 2 we brought home straight from the hospital. Needless to say, it is a very life-changing experience.
Yeah, without a doubt, and God bless you and him. So you and your 86-year-old husband are raising 4 young children right
Yes.
now, and you live in Palestine, but you took the time to drive down here. Did your husband come with you, or is it just you today?
He was going to, but he didn't feel very good today, so I brought my daughter instead with me.
Wonderful. Well, thank you for making being here a priority today.
It
I
was
think,
very much a
I
priority
think it's
to me.
important for the committee to hear your perspective on this because you were, or maybe I'll ask it as a question. You were, and I think you mentioned this in your testimony, you were on the original jury that convicted Robert Roberson. Is that right?
Yes, sir.
And one of the reasons I think it's so important we hear from you is because I hear a lot of people saying right now, and that we've got to trust the jury in this case. And you were one of them, and the jury convicted him of murder. And you were one of the jurors that cast a vote to convict him of murder. Is that right?
Yes, sir.
So it's really important we hear from you. How, and I've got several questions. So as short as you can kind of make this, what made you feel that he was guilty of murder that led you to cast that vote of guilt for him?
Because Nikki was dead, and from what we were told about the shaken baby syndrome and showing the pictures of her brain with all the bleeding up in her brain, there was no other explanation that was given to us of anything else that could have happened to her.
Yeah. So it would be fair to say, from your perspective as a juror, this case was about shaken baby syndrome.
That was the only thing that was discussed or told to us that it was about.
That's the only thing.
Only thing. Nothing else was ever told to us, ever discussed with us. Any other options was never told to us.
The start of the trial, the middle of trial, and just to be clear, you were there for the guilt phase, and were you also there for the sentencing phase as well?
Yes, sir. I was there through it all.
And for the whole time, whole time,
Whole
shaken
time.
baby syndrome.
Yes.
Nothing-
Nothing else was ever told to us.
Nothing else. So I'm going to ask you a question anyway, just because I've written it down. I want to ask it to you. Were you told anything about this little girl, Nikki, being beaten?
No. In the jury room, that was nothing we ever discussed. The only thing we ever discussed in the jury room was the shaken baby syndrome.
So you heard nothing about Nikki being beaten as an explanation for what you witnessed in the jury room?
No.
You never heard witness testimony or arguments from the prosecution that her father, Robert, or anybody else had struck Nikki, or that blows or hits to the head by somebody is how she ended up in that case in the hospital?
No.
Did you hear any discussion of sexual abuse in the trial at all at any time?
Yes.
Did you have to vote on that? Was he ultimately charged of sexual abuse?
No.
But to the best of your recollections, you and the jury, are you testifying here that you and all of your jurors heard allegations, and maybe I'll ask this, were they graphic allegations that you heard?
Yes, sir.
Yeah. Did you ever see any witness or any evidence to corroborate those things that all of you jurors were told about allegations of sexual abuse?
No, all it was, what we were told, there was a nurse that testified. She testified that she was a certified sane RN and that she had found these tears and everything else, and that is what we were told. She told this, and it was brought up several times, but then when it came time toward the end of the trial, they disappeared. They were never in
Charges?
Charges. They were never charged. We never had any discussion of them in the jury room. There was no other type of discussion about it in any size, shape, or form. And then come to find out, she was not even a certified sane nurse.
And forgive me for the graphic nature of this, but you were told of sexual abuse to such an extreme that tearing was implicated and involved, and told to you, the jurors. The person who said this represented a certain certification that upon cross-examination, they had to admit they were not even certified to be discussing the matter. Is that right?
Yes.
Is there any reason for you to believe that he was guilty of sexually abusing Nikki or any other child?
No. Except for what she said.
So this case was a shaken baby syndrome case, start, middle to end. Is that your recollection?
Yes, sir. And also to my recollection, believe the prosecution even got either it was a teddy bear or a baby doll and got it up and shook it to demonstrate to us what shaken baby syndrome was.
I'm really glad you mentioned that. Let's talk about that for a second. Because what is being thrown around right now, and we'll get to this more in a minute, people keep saying, the state right now, to defend the execution, they are saying that Nikki was beaten several times on the head. And you just testified a second ago, if I heard you right, you never heard anything about that.
No, sir.
Do you have any recollection of multiple impact sites that Nikki had been beaten on multiple parts of her head?
No, sir. The only thing that maybe had been mentioned was she might have had a small bruise from where she fell out of bed.
Yep. Were there any photos or discussions that you saw, or any evidence you saw that made you think that anything of substance, and certainly of sufficient force to kill a baby or a 2-year-old, was on her head? Did you see any photos of severe bruising on her faces at all?
No.
In the photos you saw, did Nikki look like she had been beaten?
No.
I want to go to this teddy bear. Did you say it was a teddy bear?
I don't remember if it's a teddy bear or a baby doll or a child's baby doll or something.
Help me understand this. Why would a baby doll or a teddy bear be brought into the courtroom? What were they doing with it?
I think they were trying to emphasize the extent of what the shaken baby syndrome was and how violently he had shook it.
Can you describe to us, okay, so that was the point. What did they do with the doll or with the teddy bear? Can you just describe what you saw them doing with the doll?
They grabbed it by its arms like this, and they just violently shake, and just tried to give us an example of what the shaking consisted of.
And they did this, did they do this because they wanted the jury to understand what could have explained their theory for what was going on inside of her brain and what they believed happened to Nikki? So was the doll kind of like a substitute for Nikki?
They were trying to make it a substitute for Nikki.
Is that what you believe? You were seeing them
That's what I
simulate what they
believed.
believed
Yes.
happened to her?
Yes, sir.
Okay. Did they ever simulate the doll being hit in the head with anything?
No.
Did they ever simulate the doll being hit in the head by Robert?
No.
Did they ever simulate the doll being thrown against anything?
No.
Did they demonstrate the doll being hit in the head in any way?
No.
So the only thing you saw that simulation with that doll on was being shaken. Is that right, or is that
That
wrong?
is correct.
Do you remember if the defense counsel objected to any of this at the time?
No, sir.
Well, you don't recall, or they didn't?
No, he didn't.
Okay.
Did they talk about, if that was the case, was there any discussion about damage to other parts of Nikki? Because, if you're shaken like that, was there any discussion about other injuries that might be intuitive if that were to happen? For example, fractures or neck tissue damage?
No, sir.
Nothing about a neck damage or any other part of her body?
No, sir.
Okay. Do you have, based on what you heard, and you sat through the whole trial, do you have any reason to believe that Robert was a violent person? Is there anything that stuck in your mind about that, based on everything you heard?
No, sir.
Were there any alternatives that you, the jury, any alternative explanations, I should say, to what could have explained what you were seeing from the medical evidence regarding Nikki, other than that she had been shaken?
No, sir.
And I jotted this down, but during your testimony, I want to make sure I heard it right, or maybe it was during one of your answers a second ago. You mentioned something about the deliberations in the jury room, and you were in there deliberating with your jurors.
Yes, sir.
What were you discussing when you were in the jury room deliberating with your jurors?
The only thing that we would basically discuss was the shaking of the baby and the head injuries with the bleeding and stuff that they showed us pictures for where they had cut her skin away from her brain. where we could actually see the whole shape and the bleeding on her brain. And they sent those pictures around for all of us to look at. And that's what we would be looking at, was all the bleeding in her brain. And that's what they told us had been done from the shaking so violently, it had burst those blood vessels.
And I want to peel at that. I mean, I assume the pictures were rather hard to view.
Graphic,
Hard to
yes.
view, and they were after the autopsy.
Yes.
Okay.
Or during, after.
During or after, but okay. Was there anything else that you can recall, you and your fellow jurors discussing when you were in deliberations in the jury room, other than, was this child shaken to death?
No, sir.
You'd have no recollections of anything else discussing this child being beat, hit, or otherwise abused?
No.
Okay. I want to go to the medical history now, because that has come up a lot in this case. What did you know about her case? What did you know about her medical history? I'll phrase it that way.
The only thing that we were told as jurors is that she had been sick, that Robert had taken her to her pediatrician, I think earlier in the week, and he had given her Finnegan. A couple of days later, she had been running a high fever. I believe we were told about 104. He had taken her to the emergency room. Again, they had given her some Finnegan with cough syrup in it, codeine. And he'd taken her back home again. And then the next thing we were told is when she had rolled off the bed, she, I guess, was okay. And he put her back in bed with him. He woke up again. She was unresponsive. And that's when he took her to the emergency
So
room.
prior to basically starting 48 hours out from her death,
Mhm.
did you have any knowledge of her medical history?
No.
And would you characterize, because I don't want to misrepresent what you just testified to there, but in the days leading up, so the 48 hours roughly, you knew about it. There was a doctor visit, hospital visit. And by the way, was it your understanding he was the one taking her to get medical care
Yes.
on multiple occasions?
Yes.
In the last 48 hours of her life?
Yes, sir.
Was there anything that you heard at trial that led you to believe that she was severely sick?
No. I just thought, what I took it as being is that I thought she basically had the cold, running a high fever. I thought she was probably pretty sick, but nobody was ever figuring out what was wrong with her.
But was there a lot of discussion in trial about her extensive medical history?
No.
Okay. I would like to ask you a few things because I think it's really important. I want to ask you a few things that we now know, and I would like to hear you just let us know if you were aware of this type of medical history for Nikki. Were you aware that there was a CAT scan done that showed only a single minor impact site to the head that had only a small amount of breathing? Did you ever see this CAT scan?
No, sir.
Were you aware, or did the jury see, CAT scans and autopsy photographs that showed only a single impact site of the head with only a small amount of subdural blood and brain swelling that would have been, in fact, completely consistent with a short fall?
No, sir.
Okay. Were you aware, was the jury aware of a post-mortem toxicology report that the medical examiner, Dr. Urban, did not consider that showed she had toxic quantities of Finnegan and Finnegan with codeine in her bloodstream at the time that the autopsy was performed?
No, sir.
I'm going to take a quick tangent here because these drugs now, are you aware that they now carry what's called an FDA black box label?
Yes, sir, because I know the pharmacy I go to won't even carry it these days.
Yep. That wasn't the case back then. And I'm going to read just a couple statements to make sure everyone understands what we're talking about when we're talking about FDA black box warning.
Okay.
I want to know if you knew this at the time y'all made your decision. Were you aware at that time, in 2002, that Finnegan tablets and suppositories may lead to, quote, potentially fatal respiratory depression?
No, not then.
Were you aware that Finnegan tablets and suppositories in patients with compromised respiratory function, such as sleep apnea, should be avoided.
No, sir, not then.
Were you aware that caution is now this is the official, this is from the FDA, caution should be exercised when administering Phenergan tablets and suppositories to pediatric patients 2 years of age and older because of the potential for fatal respiratory depression?
No, not then.
And were you aware then that excessively large doses of antihistamines, including Phenergan tablets and suppositories in pediatric patients, quote, may cause sudden death?
No, not then.
Yeah. Nikki had been prescribed these drugs, these cough syrups, that do metabolize into morphine. And this was in conjunction with the fact that she had a severe respiratory infection. Were you aware that she had a severe respiratory infection?
No, sir.
Okay. Are you aware of the evidence that has established that Nikki's heart, after she was admitted, was resuscitated even after her brain had already become brain dead? It's called non-perfused. But that blood thereafter, over the course of 2 days, was being pumped through her resuscitated heart to her brain, but it didn't have the ability to end the brain. Did you know about this at all? And did anybody ever tell you that this could have possibly explained all the blood that was up there?
No, sir. From what we were basically under the understanding of, that when she got to the emergency room, she died sometime later that day. We were never told she was put on life support or anything like that, and actually survived for 2 more days.
So really quick, 'cause I want to pull at this. You testified you saw these autopsy photos where the dura had been pulled back, and you saw all of the horrific blood up there, and you were told that was a result from shaking, but you were never told that for 2 days they had been pumping through her artificially stimulated heart blood up into her head.
No, sir.
Okay. Are you aware that there's evidence that after Nikki was moved to Children's Hospital in Dallas, she was receiving epinephrine and 3 other drugs that stimulate blood flow and raised her pulse to over 200, adding to the blood flowing in and under the scalp and accumulating in the subdural space, yet it was unable to enter the brain? Did you know about that?
No, sir. Like I said, I thought she had died there at Palestine Hospital later that day.
Were you aware that when the medical examiner, Dr. Urban, conducted an autopsy, she observed an accumulation of subdural blood, but that the medical examiner made no attempt to reconstruct past events to assess how that accumulation in the subdural space of her brain had occurred during Nikki's hospitalization, and that despite expert medical witness to the testimony, she determined that that blood was a sign of multiple impact sites, even though that's not consistent with anything that's outside of the exterior of her brain. Were you aware of any of this?
No, sir.
Are you aware of the evidence that is now well established that Nikki, who had been very ill for most of her life, had high fevers during her last week? And you might have mentioned you knew about the fever. Are you aware that she had an unidentified respiratory infection that included double pneumonia, both viral and bacterial? Were you aware of this?
No, sir.
Were you aware that the pneumonia had advanced to the point of sepsis?
No, sir.
Were you aware of her having any blood clotting conditions or disorders that might have impacted how well she or how easily she bruised, and that could have impacted brain activity subcutaneously?
No, sir.
Okay. Were you aware of the evidence and the witness testimony that I have heard directly from forensic lung experts that testified that her pneumonia had progressed so great over the period of probably 3 weeks that he didn't understand how at the time of death her lungs would have been capable of even absorbing enough oxygen to maintain life?
No, sir.
If you had known that, would that have made a difference in how you voted in this case?
Yes, sir.
How big of a difference?
Very much difference. I would have found him not guilty.
In 2002, were you aware that Mr. Roberson had autism?
I was not aware of it in 2003, the day of the,
The
year
trial
of
was
the
2003,
trial.
that's right. And this is important because I have had law enforcement testify here to this committee that he had a really flat affect. How would you describe his demeanor at trial, and did that have any impact on your views of his guilt or innocence?
It didn't have a whole lot, but I'm going to say it probably did have some. He just basically sat at the table, didn't look at us, didn't pay how much attention, just basically stared more or less straight ahead.
Did you find that odd?
It was kind of odd.
Would it have struck you as less odd if you knew he was had been diagnosed as being
It
on the
probably
autism
would have,
spectrum?
because I would have explained what his behavior was.
Do you remember, going back to his attorney at the time, do you remember his attorney, was he arguing more that Robert was innocent of any crime, or was his focus more on what type of punishment he should receive? How would you talk about his defense attorney? How would you describe it?
I thought he was more worried about what punishment he was going to receive. I think he more or less accepted that he was guilty of the shaken baby syndrome, and he was just more worried to try to get him the lesser punishments.
Yeah. Did he ever, the whole trial, did the defense attorney ever present you with other explanations for the shaken baby syndrome triad, the swelling brain, the retinal hemorrhaging, and the subdural bleeding? Did he give you any other explanation that could have explained those three things?
No, sir, that's what made it so, more or less, this is what it is, because he gave us no other options or any other type of options that we could have considered.
Would it have made any difference to you if at the time, if you had known that there are many other things that can result in all three of those triad of symptoms?
Yes, it would have. It gave me something else to have considered.
So you considered nothing else?
Nothing else, because nothing else was presented to us.
So you saw the three symptoms: shaken baby syndrome, the prosecution said it, and the defense attorney said it. Is that right?
That's right.
Okay. So just one last time, nothing you and I just got done discussing, all that medical evidence was not presented to the jury, and you were not deliberating on that in the deliberation chambers.
No, sir.
Tell me about your history on this in recent times. Are you aware that he had an execution date set in the past few months?
Yes.
How did you hear about that?
I actually read it on my phone, because I keep a bunch of news feeds and stuff like that, because I like to keep informed of what's going on.
So you heard about it in the news.
Mhm.
Okay.
I've also kept up, like, when he's had different hearings at different things, it comes across, and I guess because I was on that trial, I have always kept up with things that has been going on,
So you've paid attention to it over the last 20 years.
off and on, yes.
Yeah. What was your reaction when you heard that they had set a new execution date for him?
It kind of got my interest more so then, but then when I started reading about all these other things coming out about the pneumonia and the sleep apnea and the double pneumonia and all this extra stuff that has just now started to be coming out that I've read about, or maybe it's been out, but I just now recently read about, it got me even more thinking, and I started thinking back about all the things that I knew about that went on in the trial, and I just realized, and I just finally came to the conclusion, he was an innocent man. And I just, in good conscience, I could not live with myself thinking that I had a hand in putting an innocent man to death.
Wow. So this had to be emotional for you. When you came to that realization, what kind of things did you do? Did you have discussion with your husband or other family members about this? How was your emotional reaction?
I had a very big discussion with my husband and with another friend of mine. And there would be times that I'd be talking about it with my husband that I would literally start crying about it, because I felt that emotional about it.
What made you so emotional that you started crying?
Because I just couldn't think about killing a man, and that's how I looked at it. My decision 21 years ago was getting ready to come to realization, and I literally, in my eyes, was killing a man that I knew was innocent, and I was going to have to live with that.
This must have weighed on you over the last few months.
Very much.
Well, for what it's worth, not a question, but just a statement. I'm confident I'm confident in this. I can speak for everybody up here. We're all humans, and nobody would expect you to be judged on 2024 knowledge in 2002, 2003. Okay. You are only responsible for what you knew at the time.
Yes.
I need to bring this back to very present day because we've had a lot of developments in the last few hours, last few days, that I would like your take on
Okay.
as someone who was on the jury. When this committee issued our subpoena, something that, just as a matter of fact, if we had not done, he almost certainly would be dead right now. There was a lot of litigation that has started, a lot of arguments. And the government, the state, and in this case, the Attorney General's office, made an argument on the day that we issued the subpoena, I can't remember if it was that day or the next day. They began arguing that Robert Roberson's case was not a shaken baby case. I would like to read you a couple quotes.
Okay.
This is from somebody in the office of the Attorney General. The evidence supports the fact that there were multiple blunt force impacts to the child's head. How would you respond to that claim?
I would like to know where they got their information